Good afternoon, everyone. Welcome to our live webinar on the changes to employment law. If I can just start by doing a couple of introductions. I'm Wendy McGarvey. I'm the Head of HR at TC Group and Head of HR Client Advisory for London and South. With me is Bruce Keir, who's also Head of HR Client Advisory for Midlands and North.
Hi, everybody.
So I'll just talk us through what we're going to go through with you all this afternoon. So we'll give you a brief overview of what the planned changes are. What does that then mean for you as a business? When we believe the new legislation will be in place? And then what's next and how can TC's HR advisory teams support you with these changes? So what does Labour's majority win mean? There are going to be significant employment law changes. They've submitted over 60 pledges with changes to be considered. Now, we're not going to go through all of those with you this afternoon, otherwise we'll be here for quite a long time. We've picked the key areas to talk through with you. Now, the full extent of these changes is not yet disclosed, so obviously we can only tell you what we know at this stage. Now, the majority of the pledges are looking to strengthen employees' rights, and a lot of them are about new day one employment rights, and we'll go through those with you shortly. There is a mixture of changes. Some of them will be changes to current legislation, some will be new legislation, and some will be just looking at strengthening existing employees' rights, and we'll talk through what all of those look like.
Yeah, so what are those planned changes? So as Wendy mentioned, we're not going to go through all 60 plus of the proposed changes today with you. We'll be here all day. So what we've done is we've handpicked a select few to talk about. Those are the ones that we believe are going to impact you as businesses the most. So we'll kick off with probably the one that's been most discussed and most talked about with, certainly with the clients that I've been speaking to, and that's the introduction of day one rights. So as it stands currently, you'll all be aware there's a number of employee rights that require a period and length of service for the employees to become eligible for those rights. So the proposal is that actually that's going to change, so a number of those change to become day one rights. Now, we're going to talk about a couple of those through the following slides, but probably to pick out the one that's been most discussed and most clients have spoken to me about is the unfair dismissal claim period. So as it stands at the moment, employees must have a minimum length of service of 2 years to become eligible to claim unfair dismissal. The proposal is that actually that's going to become a day one right. But actually what we think that will mean is that will be a post-probation period, day one. So for you as businesses, it's going to be really important to ensure that your probation period process is very slick and you're able to achieve the goal of the probation period, which is to assess the employee's suitability for the role. That will also mean that we'd advise on a number of sort of reviews of probation period, whilst the probation period review process, but also the contractual terms that you've got for your probation period, and making sure that that is very clear and leaves no ambiguity and protects you as employers. The second one then that we're going to talk about is the removal of the employee and worker distinction. So as you're aware at the moment, there's a clear distinction between an employee and a worker, with the employee benefiting from a number of rights that the worker currently isn't entitled to. But the proposal is that actually that will change to create one basic set of rights and protections that will cover across every worker and every type of worker that there is. Now, this means that there are going to be some major changes in that. And so that means that there's going to be a significant period of consultation that's going to be required over this specific piece of legislation. So we think that actually this isn't going to be introduced for another sort of at least 12 to 18 months, and that it's going to be one that's further down the line. But as we get more information, as we become more aware of the timelines around this one, then we will let you all know. That leads quite nicely into the changes into 0-hour contracts. So you'll see there, and the headline has been it's banning 0-hour contracts. But actually, what the proposal, when you sort of dig down deeper into it, is it's going to sort of look to remove the one-sided flexibility that there currently is toward the business. Or the perceived flexibility towards the business. And the proposal is that the employer then must provide a base level of security for the employee. And so that the employee has the right to a contract that accurately reflects the number of hours that they are regularly doing. So that will be taken over, we believe, a 12-week reference period. There'll also be a change to the amount of notice that will be required for employers to change those working times, and that will become mandatory. So we're not exactly sure what the length of period of notice that will be required is, but what we are sure of is that it will become a mandatory piece of legislation. So again, there'll need to be changes to contracts of employment, for example, and processes that you go through in this particular piece of legislation. So again, updates to contracts are going to be required on this one. Pick out another few here. So changes to sick pay. So we talked about the day one rights earlier. So sick pay is another one of those that's going to be affected. So currently to receive statutory sick pay, there's a period of a waiting period of 3 days. That's going to be changed so that sick pay becomes a day one right. So from the first day of sickness, employees will be eligible for statutory sick pay. And there will also be a change of the rate of statutory sick pay to better represent the earnings that the individual has. So we believe that that's going to mean sort of for a lot of employees, it will mean an increase in the amount of statutory sick pay that they'll be entitled to, or the amount of statutory sick pay, and there will be a removal of that sort of single rate. So that will be some changes to your administrative processes and certainly from a payroll perspective. In terms of then flexible working, so again, this is a slight change to the wording around flexible working here. So many of you may be aware that currently flexible working and the ability to apply for flexible working is a day one right as it stands right now. What that's going to change to is actually making it the default. So rather than having to apply for flexible working, the employee will be able to come and say, well, this is the role that I'm in, and I believe that I can do my flexible hours over these hours. And that will be the default unless there's a valid reason and it's not reasonably feasible for the employer to implement that. So what not reasonably feasible means at this moment in time, we're not fully aware of, but as we get more information about that, then of course we'll make you aware. But it is going to be a significant change into the way that you're going to manage. So thinking about sort of the recruitment process, thinking about the role that you're going to be advertising for is going to be really, really important there. The next one on the list there is the right to switch off. So this is currently a piece of legislation in many European countries, and basically what it's going to introduce is the ability for employees to switch off. So it means that employers won't be able to contact employees during designated times, so not late into the evening or early in the morning. Now, I'm sure that a number of you, as good employers, will be aware of that and won't be contacting employees late into the night or early in the morning. But this is to ensure that there's a piece of legislation in place to stop that from happening and sort of trying to change that always-on culture. So it'll be interesting to see sort of what comes out a little bit further down the line of this, but we believe that there's going to be some set times in the day dependent upon the contract that the individual has. And again, this right to switch off will need to be a policy that will need to be introduced, or a contractual term that will need to be introduced into the contract of employment. The final three that we're going to sort of just highlight today as this initial sort of kickoff is so to start with the tribunal claim period. So currently that's at a period of 3 months for an employee to raise an employment tribunal claim. That's going to extend to a period of 6 months. So lengthening out that period of time for the employee to consider if they wish to raise that employment tribunal claim, and give them more time then to process the claim itself and come through. The next one is the changes to national minimum wage. So this has been described, the introduction of this has been described as the genuine living wage that's going to be introduced, effectively removing the age bands that currently there is within the national minimum wage structure. what that's going to mean for you as business owners and managers is that where it's going to really affect business owners that employ a number of people on national minimum wage, and especially those that employ young workers. So there's going to be a significant increase in the monthly payroll. If that's as we believe, everybody's going to move up into a top banding of national minimum wage. And then finally, bereavement leave. So a number of businesses will provide a period of bereavement leave as part of their statutory policies. But what this is going to do is provide enhanced bereavement leave to all employees and make it a mandatory statutory policy, which comes in across all businesses. So again, what that looks like in more detail, we don't have that information right now, but as we go through this period and more becomes available, and as Wendy said, in future webinars, then we will keep you up to date on that. So what does this mean for you as businesses, and what's it mean for those businesses that are going to be affected? So as I mentioned numerous times here, there's going to need to be updates to contracts of employment for both new and existing employees, updates to policies for new and existing employees, which then will lead into changes for the way that you're going to have to manage all of your employees. So there's going to need to be process changes, which are going to require the training of managers to manage those employees with the changes that are put in place. So there's going to be a significant change. It's probably one of the, or the biggest change that we've seen from an employment law perspective for a number of years. As Wendy's mentioned, and we'll go into more detail on, we're going to be there to support you throughout this process, and we're going to run a number of these webinars. So if you do have any questions, then please do let us know.
So when will the legislation be in place? Well, they've submitted their 100-day pledge. So from the date that they've submitted this, the date on the calendar for everybody to mark is the 25th of October this year. So this is the date where we believe a number of the changes will come into force. However, they're not going to be implementing every single one on that one day. It's not going to be manageable. So what we believe will happen is there'll be a number that will come in on this date, but there'll then be a number of others that will come in future, whether that's 12 months later, 18 months later. As we said, we don't know for sure at this moment, but that's what we believe will be happening. So what's next, and how can our HR advisory team at TC support you? So this is our first webinar, and as Bruce has alluded to, we will be doing more as and when we know more. So please keep your eyes peeled for notifications from us, and we'll let you know when we'll be holding more seminars. Think about the changes that are going to come into force, and think about things like your contracts, your policies, your processes. And our HR advisory team can certainly support you in reviewing and updating those if needed. We can also do a full HR health check if that's what you would like. Now, if there's anything you would like to get in place before these changes come into force, we would be happy to support you. Now, what we're going to do now is launch a poll for you to let us know if you'd like us to get in contact with you following the webinar.
Brilliant. So we'll just give you a couple of minutes, guys, to answer this one, and once we're nearly there. Perfect. We're almost there. I think we've got a few more final ones just to do, and then we'll move on. Just give it another minute or so just for the final. I think there's another 10 or so to go, and then we'll end the poll. Perfect. We'll close that poll now. But thanks very much, everybody, for inputting there. And if anybody has, I know there was a final few that we maybe didn't capture there, but if you do have any questions, there'll be detail about how you can contact us shortly. Perfect. So any questions from anybody? We've got there's a Q&A facility that is that we've opened. So if anybody has any questions, feel free to pop them into the Q&A section that you'll find at the bottom of your screen. We have had a few questions that have been provided to us before we've started the session today. So thanks very much for those of you who've provided them to us before the session. So I'm just going to pick up a couple of those as we go through now. So the first one that came through is when will we actually see all of the changes come into play? So Wendy mentioned that the date of the 25th of October is when they will be put forward, but it's likely that we're going to actually see them implemented over the next sort of 12 to 18 months. There's going to be some that will come into play sort of fairly quickly. We think April 2025 there's going to be a number that come through to, and then others may be further on from there. So as we get more information and more detail on the timeline, we will let you know. The second one that's come through is when it moves to day one rights, how will this affect current employees? So we believe that any legislation that comes into place for them, so for example, the day one rights, all existing employees will be subjected to those pieces of legislation from that day. So there'll be no need for any existing employees to work any further periods of notice to for example, for unfair dismissal if they've not worked under 2 years service currently. As soon as that piece of legislation changes, they will be eligible to claim from that day. The third one that's come through, so even though an employee has the right to consult a union rep, will the new policies allow unions to have more of a say in the business? So, so the Labour government has said that they'll look to update union legislation so it's fit for modern economy, removing the unnecessary restrictions on trade union activity and ensuring industrial relations are based on good faith negotiation and bargaining. So we believe that it's going to be easier for trade unions to gain recognition, but that doesn't necessarily mean that they'll have a say in the business. But what it does mean if they are recognised is that you'll have to take some time in consulting with the trade union before you look to make any changes to any people-related sort of policies or contractual or wage-related decisions.
I can see coming through. If I pick up a couple of these, we're not going to have the time to answer all the questions here on the webinar. So if we don't get to your question, we do have it noted and we will come back to you following the webinar. A common one that's on here is about apprentices, and will apprentices get the standard national minimum wage rate? The full answer to that is we're not 100% sure on what that rate is going to be as yet, but I would like to think that there would be a rate for apprentices, and then there would also then be one rate for all age bands. But again, we're waiting for that further guidance on that. Another common question we're receiving on here is about probationary periods and how long can we have them for. At the moment, there is no legislation in terms of how long that can be. Our advice is normally 6 months. It's quite a good period to review. And if there are any issues within that probationary period, as long as you're going through the process, you can then look to extend the probationary period if there are concerns. But again, there may be some changes to that with the day one rights. It's something that we need to wait to see.
I think we've got another one here on flexible working. So so they've asked, is that giving the employees the right to request flexible working from day one, or is it your understanding that flexible working will be, oh, sorry, it's just jumped out there, the default for employees, and the onus is on the employers to refuse? So yes, it's the latter there. So the flexible working will be the default for employees, and then the onus will be on the employer to come with a reasonable reason why it's not feasible for them to allow that flexible working. So it's going to be something that's going to need to have a lot of thought put into it from an employer's perspective as to why that flexible working can't be allowed, and certainly that's something that we can support with in terms of that thinking and helping with each role that you'll need to look at there. Any other sort of big questions that you've pulled out, Wendy? That
I've put the bereavement. Is bereavement leave going to be paid for by the government like SSP is? We're not sure. We're assuming it's going to be it's a statutory rate. But again, at this moment in time, we have no further details. But as soon as we do, we will obviously include that in a future webinar for you.
Another one that's come up a couple of times is what will happen if a current employee refuses to sign a new contract. So these pieces of legislation that are being introduced are exactly that. So they're pieces of legislation. They're not sort of changes that the employee will be at a detriment because of. So what we'll sort of advise, and certainly we can support with the communication around that and what it means for them. But as long as you're not then going to sort of go and change other terms and conditions that they have and other benefits that they have, it should be a hopefully fairly straightforward one to get the employee to understand the changes that are going to be implemented and support them in that understanding to enable that piece of change to happen and for them to sign the new agreement. But again, if anybody has any issues with that or the understanding of the employee, then we're more than happy to support with that. Okay. Brilliant. Any other questions that we want to run through, Wendy? As Wendy said, we've got a number through today, and we don't want to keep you any longer than we need to, but we will provide answers to all the questions in writing after the session today.
If SSP is going to be made in line with earnings, will any all be reclaimable, say for small employers? Obviously, that was changed a number of years ago in terms of it not being able to be reclaimed. Whether now, because they are going to say it's from day one and it will be a different rate, in their words, a more genuine living wage, whether they change those rules, we don't know at this stage.
Another one that I've just seen here is, will this apply to Scotland too? So at this stage, as you may be aware, if you're asking around Scotland, there are some slight differences in employment legislation in Scotland as there is within England and England and Wales. So we believe that there will be a number of them that will be the same, but there may be some slight variances as there is in a lot of employment law within the two different countries. Yeah. Okay, so we'll just move on to the next step. Cool.
So thanks everybody for watching our webinar this afternoon. If you've got any other questions that haven't been answered, please do get in touch with us. The webinar has been recorded, so you will all receive a copy of the webinar recording by the end of this week. It will be sent out to you directly from our teams. Thank you.